Hi, I'm Sheila, and today I'm gonna be presenting to you a case in relation to Article 26, Paragraph 2 of the Family Code of the Philippines, which states that where marriage between a Filipino citizen and a foreigner is validly celebrated and a divorce thereafter is validly obtained abroad by the alien spouse capacitating him or her to remarry, the Filipino spouse shall have the capacity to remarry under the Philippine law.
Day! Day, kilig ka sa kapag day, gwapo na may pasam English, day. Tapos, gwapo gid siya! Mas gwapo sa Campiro Pascual, day.
Huy, dapya, naunsak ka. Mura kag gikilatan, dirag color, day.
Sa day, nahod ko, day. Kabalo ka, day. Nag-chat siya sa kuwan, day. Yung man, siya next month. Basi mag-propose siya siya ka, day. Tapos nagpakasal kami, day. O, di ba, mo kita ka sa girl.
Seryoso, nagig ka na niya?
O, alangan, day. Iya ba naman ang gilig mo pakaslan?
Agoy, ni mo, day. Kanang imong gugmang giatay, day. Mahupas, sabi nagpila ka bulan, pila ka tuig. Mainding na mo na sa divorce.
Kabiter ko ni mo, Tess, no? Ikaw na mahappy sa kuha sa friend ba? As a friend.
Hoy, pag sure diha, day. Di na sa ingona, di ko mahappy para nimo makita ka gugma o kinsa man ang ispignuhan na. Ang ako lang, basing mabot ng panahon na maghinilaka ka sa kong atubangan. May kagu, sakit kayo, Tess. Dili mo kinata siya para sa kong kagwanga to. Hoy, may pag-iya ka dira, magpuyo ka, day. At imana imong English. Bagsak-bagsak, magkika sa quiz. Taro nga ba?
Oh, maninukod mo pong katis, uy. Ano pong anak po? Katuwan di ako, unsa ganitong English. Sa, where are you going? I'm fine, thank you.
Puyo day, basi maparehag ka para sa akong Auntie Marlene day. Katugong nakasawag Japanese. Karon, di ba naslay anak? Nagbuwag yapon sila day, nag-divorce siya. Pero, ang problema day anak day nung ang diborsyo, dili day siya acknowledge diri sa Pinas. Or lisod siya ang process para ma-acknowledge siya day. Muto magkasukaso pa ka day. So before ka magminyo day, tarunga gyud labi nagka ng afam. Pero noon may chance pa ka mag-win na mag-divorce day.
Day, wag pa kami nagpakasal. Divorce naman dayon ka, day. Bitter ka sa friend. Wag nang kay kalipay for me.
We have here a case of Marlene Nullada, the petitioner, versus the Honorable City Registrar of Manila, Akira Ito, Shin Ito, and all other persons who have or claim any interest as the respondents. GR number 224548, January 23, 2019. Before we go to the facts of the case, let me introduce you to the parties involved. The petitioner, namely Marlene Nullada, was born on September 3, 1968, a Filipino citizen and married to a Japanese national, namely Akira Ito, on July 21, 1997, and divorced him on November 16, 2009. The respondents of the case is the Honorable City Registrar of Manila, Akira Ito, Shin Ito, and all other persons who have or claim any interest. Akira Ito is the ex-husband of Marlene, while Shin Ito is the fruit of their union. So now let's go to the facts of the case. On July 29, 1997, Marlene and Akira got married in Katsushika-ko, Tokyo, Japan, as evidenced by the report of marriage issued by the Philippine Embassy of Japan. The document was registered both in the local civil registry of Manila and the National Statistics Office Civil Registry Division. Their union resulted to the birth of the child named Shin Ito. Their relationship, however, turned sour and later on decided to obtain a divorce by mutual agreement. In 2009, Akira and Marlene secured a divorce decree in Japan. The divorce certificate was issued by the Embassy of Japan in the Philippines. Marlene and Akira's acceptance of notification of divorce by mutual agreement was supported by acceptance certificate issued by the head of Katsushika-ko in Japan, and an English translation of which formed part of the record. As she sought for recognition of the divorce decree in the Philippines, Marlene filed in RTC petition for registration and or recognition of divorce decree and cancellation of marriage that was filed under Rule 108 of the Rules of Court. So now you might be wondering what happened in the RTC. On January 21, 2016, RTC rendered its decision denying the petition on the grounds that 1. Article 17 of the new Civil Code is a policy of non-recognition of divorce. Number 2, for the fact that Marlene also agreed to the divorce and filed jointly with Akira, barred the application of the second paragraph of the Article 26 of the Family Code, which would have otherwise allowed a Filipino spouse to remarry after the alien spouse had validly obtained a divorce. Number 3, while the intent of the law is to equalize Filipinos with their foreign spouse who are free to marry again after the divorce, the Filipino spouse cannot invoke the intention of equity behind law when he or she is an initiator or active participant in procuring the divorce. It's sad, but it's what happened in RTC. So, Marlene moved for reconsideration, but her motion was denied by the trial court via an order dated April 26, 2016. This prompted Marlene to file the present petition for certiorari on the Supreme Court. The issue of the case is whether or not a divorce mutually agreed upon by the Filipino and foreign spouse is enforceable in the Philippines. Now, how did the Supreme Court rule, or what is the view of the Supreme Court regarding the issue? Yes, a divorce mutually agreed by the foreigner and a Filipino spouse is enforceable in the Philippines. Under the law, where a marriage in between a Filipino citizen and a foreigner validly celebrated and a divorce thereafter is validly obtained abroad by the alien spouse capacitating him or her to remarry, the Filipino spouse shall have the capacity to remarry under the Philippine law. The facts in this case is similar to the recent case of Republic of the Philippines versus Marlene Taniedo Manalo, which was promulgated by the court subsequent to the filing of this petition, applying the same legal consideration and considering the same factual milieu that was attended in Manalo. The present case warrants a reversal of the RTC's decision that refused to recognize the divorce decree that was mutually agreed by Marlene and her foreigner spouse in Japan solely on the ground that the divorce was jointly initiated by the spouses. The dismissal of Marlene's petition based on the trial court's interpretation of Article 26 of the Family Code is erroneous in the light of court's disposition in Manalo. The fact that the divorce was mutually agreed by Marlene and Akira was not sufficient ground to reject the decree in this jurisdiction. While Marlene and Akira's divorce was not disputed by the OSG, a recognition of the divorce, however, could not extend as a matter of course. Under prevailing course and jurisprudence, the submission of the decree should come with adequate proof of the foreign law that allows it. The Japanese law on divorce must be sufficiently proved. Because our courts do not take judicial notice of foreign laws and judgment, our law on evidence requires that both the divorce decree and the national law of the alien must be alleged and proven like any other fact. Marlene failed to satisfy the foregoing requirements. The records only include a photocopy excerpt of the Civil Code of Japan, merely stamped Library Japan Information and Culture Center, Embassy of Japan, 2697 Rojas Boulevard, Pasay City, 1300. This clearly does not constitute sufficient compliance with the rules and proof of Japan's law on divorce. In any case, similar to the remedy that was allowed by the court in Manalo to resolve such failure, a remand in the case to the RTC for further proceedings and reception of evidence on the laws of Japan on divorce is allowed, as it is hereby ordered by the court. The petition for certiorari is granted. The decision dated January 21, 2006 of the Regional Trial Court, Batch 43 of Manila in Special Proceeding, Case Number 14-13-2832 is reversed and set aside. The case is remanded to the Court of Region for further proceeding and reception of evidence as to the relevant Japanese law on divorce. Thank you.
So friends, let us recap atong Bisayaon para mas masabtan ug mas intense. Ang Article 26, Paragraph 2 of the Family Code of the Philippines, ang sakop niya is katong mga Pinoy nga naminyo of foreigner and then eventually nag-divorce sila to capacitate the foreigner husband or wife to marry again. In turn, ang Pinoy as well, pwede na sila makaminyo under the Philippine law since dili allowed sa ato ang divorce according sa Article 17 of the Civil Code. Ang question karon is if mutually agreed ang divorce or ang nag-initiate sa divorce is ang Pinoy or actively participated ang Pinoy sa pag-file sa divorce, recognizable ba Japon ang divorce decree diri sa Pilipinas? According naman sa Supreme Court, yes, mutually agreed divorce by spouses is enforceable in the Philippines based sa iyahang disposition sa case sa Republic versus Manalo. Dili sufficient or nga i-dismiss ang case on the grounds na appeal lang ay ang nag-initiate lang sa divorce is ang Pinoy. Kailangan lang para ma-recognize ang divorce is upon submission sa divorce decree, the Philippine spouse or katong nagpetition also need to submit the existence or proof of the existence of the foreign law that allows the divorce.